Hi, everyone. It's going to give you everyone just a minute here. I'll flip it on me for just a minute. I'll give everyone a minute to come in. We're going to do a live Q&A session with attorney and legal analyst Philip Holloway about the Bill Cosby ruling today. I'm just going to let him tell you everything that happened and what he thinks is going to happen. We'll give you a few more minutes to come online here. This is new to us here at Court Chatter, doing it live on YouTube, so hopefully we can do this going off without a hitch. And I'll bring Phil in right here. There he is. Hi, Phil.
This is my driver on it. I see I'm having to use two screens if anybody's on. And just so you know, I see the chat over here to my right. So if I'm looking at any questions, I'm looking over here to the right for that reason.
Okay. All right, I see that we've got, let me say hello in the chat and see. Okay, for those of you that are just joining us, get your questions ready. You can put them over here on the chat box. You see the chat box on the right-hand side of our stream here. You can put your questions there for Philip Holloway. He's the expert here. Anything to do with Bill Cosby. So let's ask him some questions. I'm going to have him start in a few minutes and tell us what happened today. You'll see both of us looking back and forth because we've got dual screens going on, just trying to make sure we catch your questions. And I'm going to let Phil take it away right now. Okay, tell us what happened today with good old Bill Cosby.
Well, do we have anybody in here? I see just you. Is there anybody else?
There's like 9 in here.
Okay.
I don't know. Yeah, they're coming in.
Okay. Well, here's the deal. For anybody who has been watching this, of course, you know that over the last couple of days, there's been a hearing in Pennsylvania regarding whether or not Bill Cosby should be entitled to what he claims is the benefit of an alleged immunity agreement with the district attorney who was in office back in 2005 when Andrea Constand originally made her claims and when he originally gave statements to investigators. They searched his home. And at that point in time, the prosecuting attorney made the rather unusual decision that he was going to defer to the civil case. He felt that the best way for him to do any justice for her was to, in his words, make her a millionaire. Now, what you have to understand is that prosecutors don't normally get involved with the civil case. They let the civil be the civil and they let the criminal be the criminal case. In this case, he felt that he did not have enough evidence to prove beyond a reasonable doubt at that time that Bill Cosby had committed a crime. That's understandable. In fact, I wrote a piece about this for CNN Opinion, and I said the same thing. Based on the information that he knew at that time, the case against him would be weak, except for the fact that he, for reasons I can't really explain, went and gave a statement to the police a year after the alleged assault, and he essentially admitted 99.9% of everything that she said happened. He did not admit that it was unconsensual. The district attorney felt he couldn't prove that beyond a reasonable doubt. About a month or a month and a half later, he issued a press release that we put out today on social media that, among other things, it said he wasn't going to prosecute because he couldn't prove beyond a reasonable doubt. And also, he said he reserved the right, essentially, and I'm paraphrasing, to revisit the issue if was appropriate. And so his lawyers filed a motion to dismiss the case based on what they said was a grant of transactional or complete prosecutorial immunity. The current district attorney says, wait so fast. That's not an immunity agreement. That was a unilateral decision by the DA at the time to go ahead and make a no prosecution decision. Well, that's not necessarily binding on the new DA, and that was what the litigation was about. And today, at the end of the 2 days, the judge ruled that there was not sufficient evidence of any binding no prosecution agreement and that the case could go forward. The second thing the judge decided today was very quickly actually denied a defense motion to have the district attorney removed from the case because the defense claims that the DA has acted unethically by failing to honor the agreement not to prosecute. So that's where we are. Kathy, what questions do we have queued up?
Okay, well, you did a great job actually covering all that. You did a Periscope last night, and we had a bunch of questions come into that. And I think it would be good to maybe talk about a few of those again, because this will be archived and then people can watch this whenever they want. So first of all, yeah, you said, how unusual is that a DA would help someone pursue a civil case?
Well, normally DAs don't get involved in that. Their decision is based on the evidence and whether or not they think, in the first place, there's probable cause that a crime probably was committed and that this accused probably committed it. DAs frequently consider whether or not they can sustain the burden of proof beyond a reasonable doubt through trial. I can tell you from firsthand experience as a prosecutor, even though I thought I could get an indictment on a case, I did not want to stand in front of a jury with one that I couldn't prove beyond a reasonable doubt. Nobody likes to lose trials. So if, as a practical matter, if we couldn't prove it beyond a reasonable doubt, it didn't get prosecuted. And so that's what this district attorney was basing his initial decision on. But what happened was, for reasons that remain to be cleared up, Bill Cosby was permitted by his legal team to give testimony under oath, again, essentially admitting to everything and also admitting that he had used quaaludes to give to women that he wanted to have sex with. He never admitted that he did anything unconsensual, so all that's, of course, in dispute. We're not accusing anybody of anything. But that revelation in a sealed deposition, which became unsealed last year, caused the current district attorney's office to reopen the case, revisit the issue. They re-interviewed witnesses. They believe now, with all of the prior allegations of sexual improprieties made against Mr. Cosby, they believe they can use those to bolster their case, and they do believe now, apparently, that they can prove their case beyond a reasonable doubt. Again, keep in mind, Bill Cosby has given them everything that they need to prove that she was at his house, that sexual conduct did occur. He admitted to giving her pills. I think he said it was Benadryl. He also admitted that he takes Benadryl, and he knows that Benadryl puts him to sleep because he takes it himself, or at least that was what he's told the police. And I'm paraphrasing. Now, I have read the entirety of the criminal complaint, but this is what he told police in the initial interview and essentially what he testified to in the deposition. So when you take that proves most of the facts and you combine it with testimony that we can anticipate from many other witnesses from other jurisdictions, and it could be things from 10, 15, 20 or more years ago potentially. And they can come in and they can say, no, he did the same thing to me. And if it's so similar, the judge can say, that is essentially his criminal signature, and therefore it's admissible under 404B, which is the rule of evidence in the state of Pennsylvania as well as in the federal court system that allows for this evidence of other crimes. So that's the new stuff that the original DA did not have.
Okay, so we have some questions that are coming in now. So we have Muriel, who says, I was surprised to learn that he would have been given immunity carte blanche when it comes to these types of offenses. What do you have to say about that?
Well, I would be surprised if a prosecutor gives someone carte blanche, or what we lawyers would say is transactional immunity or complete immunity. It's not common. The more common type of immunity is what we call use or derivative use immunity. It would be possible, for example, to allow Mr. Cosby to testify to or to give the deposition testimony, but prevent the prosecution from using the deposition testimony or anything that they learned from it in any subsequent prosecution. Now, that would prevent him from claiming the Fifth Amendment and would permit the plaintiff's lawyer in the civil suit to be able to depose him, because if there is a threat of prosecution, he cannot be compelled to testify in either a criminal or a civil case. If those of you who are watching this now are familiar, I'm sure you may be, with the most recent Freddie Gray trial where there was a hung jury. They've offered is it Cesar Goodson, I guess? No, I apologize, and I'm drawing a blank. the first defendant to go on trial in Freddie Gray. They offered him
William Porter.
Porter, that's correct. They offered Mr. Porter use immunity to try to force him to testify in the subsequent trials, and that issue is up on appeal, or they're fighting that now because the DA uses immunity to force somebody to testify because it takes away their the possibility they could incriminate themselves.
Okay.
So yes, Muriel, I apologize, is correct. It's unusual that a DA would do it, and of course the current DA disputed that it was ever given, and the judge agreed that there's not enough evidence to support that carte blanche or transactional immunity was given.
Okay. Taylor's asking, do you know when the final ruling will be? But we have that today, right?
We had the final ruling on the two motions that were before the court, the issue of immunity combined with the question of whether or not the prosecuting attorney should be removed from the case. Essentially, and I'm paraphrasing, the defense has alleged that this was a political prosecution, and for that reason, and for alleged ethical violations such as not honoring the agreement that didn't exist, that the DA should be removed. And it took the judge about 15 or 20 minutes, I think, to get rid of that issue and to rule that there will be a preliminary hearing to establish probable cause, and that will be in March. I see that. Muriel also wants to know, he thinks he's covered from prosecution up till an hour ago. Well, I think Bill Cosby actually believed he was immune from prosecution. Otherwise, and this is where I agree with the initial DA who testified for most of the day yesterday, Bill Cosby would be extremely foolish to sit down under oath and give testimony and essentially incriminate himself, at least to the point that he admitted to the conduct. He never has admitted, and let's be clear, he's never admitted that it was non-consensual. So, but merely admitting that you were there when something criminal was alleged to have happened, that in and of itself is incriminating. And so by agreeing to give this testimony, he would have had to have waived or ignored his Fifth Amendment rights. And I can't imagine someone like Bill Cosby agreeing to a deposition when his lawyers have said, hey, you still could be prosecuted for this. So I really believe that everybody actually believed that he had immunity. That was a gamble. In retrospect, it turned out to be, according to the judge's ruling today, incorrect. It's unusual to rely on a press release signed by a prosecutor as evidence of an agreement, a formal agreement to not prosecute. That press release said that the DA did reserve the right to revisit the issue if it were appropriate. So it's a little bit unclear why his lawyers put all their faith in that one document. They also said there was some oral discussions between the original DA and Cosby's then lawyer, who's now deceased. And of course, we don't have that person to testify. All we have is the one side of the conversation that took place 12 years ago.
Okay, so I asked you this last night, but I'd like to talk about this. Everyone asks about this. You have said that all these other women that have all these accusations, their statute of limitations have run out, so he can't be charged in those cases. But can these women testify in this if a trial is coming? And even the women that were so long ago that they have no legal stance, can they testify?
Yes, they can if they meet certain legal requirements. That Rule 404B and the rules of evidence that I referred to a minute ago, it has to do with, it's called evidence of prior bad acts. So let's just say hypothetically there's a young woman in Oregon or California or Texas or anywhere in another state, even maybe in another country, who would come to court and would say, he did the very same thing to me under almost identical circumstances. If it was outside the statute of limitations in whatever state the event allegedly happened, if the judge is satisfied that it's relevant and that it meets those criteria, that it's so similar that it essentially amounts to his criminal signature, it is admissible to show lack of mistake, modus operandi, and things like that. So if you can bring in 10, 12, 15, or 20 of those types of witnesses, that will carry the ball over the goalposts potentially, if the jury believes them, to show that the conduct in this case was not consensual. I hope that clears that up. It's a little bit in the weeds, but that's the short answer to a long question.
Yeah, that does. Thank you. Okay. Karen wants to know.
Somebody says, I've been hearing about an email. Is there an email from the former DA? Didn't that email, if it exists, grant immunity? Well, the email was sent last September, if I'm not mistaken, to the district attorney at the time, and now she's no longer in office. Mr. Steele was the DA elect, and he took office officially January 1st. But as a practical matter, Steele is the one that was been running the show. So the former DA sent an email, and he said essentially, and I'm paraphrasing, we had an arrangement that I wasn't going to prosecute. You may have some problems. I can't imagine that a judge would let you prosecute this case unless you can do it on something other than the deposition testimony. Now, that qualifier, when he says, if you can do it on something other than the deposition testimony, that suggested to me when I first heard about it that he had granted some type of that limited immunity known as use immunity, which basically means you got to make the case without using the depositions or anything you learn from the deposition. So that email came from last fall, and that email itself didn't grant immunity. It was just a discussion between the former DA and the current DA that, there was some type of an arrangement that we had, and you need to proceed cautiously. So the current DA investigated the matter, and they were satisfied they were on solid legal grounds, and so they moved forward. That email, by the way, in my view, was a little bit inconsistent with the testimony given by the former DA in court when he said it was his intention to forever and ever prohibit the state from prosecuting Mr. Cosby. That does not square with the email, because the email left open the possibility that he could be prosecuted. It just was qualified on it being on something other than the deposition testimony.
So why the discrepancy in that?
That's a good question, Kathy. That was something that, of course, I wasn't in the courtroom. I was relying on reports from people that were in the courtroom watching it in real time, and I don't know. It may have been addressed, but I do believe he was cross-examined on other statements that he made. Some newspaper articles, I think, quoted him at the time saying he reserved the right to potentially reopen the case, and things like that. And essentially he said, no, they misquoted me, or they got it right, or they got it wrong. So I'm paraphrasing, but there were lots of instances that he was cross-examined on where he arguably gave inconsistent statements to the testimony that he provided in court over the last couple of days.
Okay, Karen wants to know, are there any new cases that are being looked at against him that wouldn't have the statute of limitations run out on him? There
was one potential case in California, if I'm not mistaken, had to do with something that allegedly occurred at the Playboy Mansion back in 2008, if I'm not mistaken.
Yes.
This week, that was proven to be false, because they were able to establish that Mr. Cosby was in New York on the date in question, and this young lady's lawsuit was dismissed right about the same time that announcement came out. So that, if it were true, would have been within, I think, the statute of limitations. But unless there's something that I'm overlooking, I'm not aware of any reports of any viable criminal prosecutions that could survive any challenge on statute of limitations. So this is the only case that I'm aware of that has any potential viability to succeed.
Okay, so then I have a question about that case out of California that was proven that she was lying. Can his attorneys use that?
Prove who was lying?
Well, you said that the case proved that he wasn't there. He was in New York at the time.
Oh, okay. So
his attorneys now use that.
All right. So that case is going to be independent, and it's not going to have anything to do with his criminal charges. It's simply another situation where it gives ammunition to the critics who say, okay, we've got 50 or 60 claimants, young women who said that he's assaulted them. A lot of people say, well, they're just piling on. These are people that are greedy. They're trying to fabricate stories just so they can make money off of the lawsuit. Well, this will give fuel to that fire and give them some ammunition in that argument. By and large, I think the overwhelming majority of the other accusers that are out there don't have that big of a problem with their cases. Now, I'm not intimately familiar with all the details, but I haven't heard any reports that he has an ironclad alibi and can disprove any of the other allegations. I haven't heard that. It's possible that it's true, but I do know that this week he had one case that was dismissed by the plaintiff out in California.
Okay, Muriel has an interesting question. She wants to know about a statute of limitations for a serial rapist, though I imagine he'd have to be convicted a few times to be classified as that. But what do you have to say about that?
There's no separate and distinct statute of limitations for someone who's committed multiple rapes. Each crime is judged and looked at on its own facts. If a hypothetical person commits a rape on a certain date and the statute of limitations say it's 10 years or 12 years and that 12 years expires, then they can never be prosecuted. But if they committed another rape a week later, that would extend the statute of limitations out for that one. So each individual offense has its own statute of limitations. The fact that someone may be a serial rapist, whatever that might mean, doesn't change the statute of limitations because it's based on each individual transaction or occurrence.
Got it. Taylor, if it turns out there's not enough proof to go forward, will the women get in any trouble? So I guess maybe in that case that we just talked about where it shows he wasn't even in the same state as when she's accusing him, can a woman get in trouble for falsely accusing someone of that?
Absolutely. There's not many crimes that I can think of, in my opinion, that are worse than sexual assault or rape. Right up there with that is a false allegation of rape. And having represented someone who's been falsely accused of it, I can tell you it destroys lives. The statistics are all over the map. There are a lot of people who think that it's somewhere in the range of 30 to 40% of all claims are not true. And then there are other studies and statistics that put it down closer to 2 to 5%. So we really don't know because it's such an underreported crime. We don't know what the statistics are on false allegations, but yes, it is against the law to falsely report a crime, and if you get caught doing it, you can be prosecuted, and lots of people are, not just for this, but for other things as well. Someone asks, will there ever appear documents or other evidence of what the deal was between the former DA and the deceased lawyer, and how can the deal become a mystery after dead? Are there no safety measures? Well, there's a lot there in that question. So the first part, will there ever appear documents? The testimony that we heard today was that no, there are no documents that exist. There was individual memories of conversations had with the deceased lawyer who represented Mr. Cosby at the time. So whatever information he had in his memory, he took to the grave. So there's no written documents. There's nothing to memorialize in the agreement. The only writing that Bill Cosby's team relied on, has been the signed press release by the old DA. Now, keep in mind, he said that he was reserving the right to reopen that if necessary. I don't really understand how someone can claim that that is a binding legal document or evidence of a contract, essentially.
Okay,
safety measures. Well, apparently in this case, no, there weren't. The safety measure would be to put it in writing. If I'm a lawyer and I'm representing somebody who has been investigated by the police for any crime, let's just say it's murder or anything else, and then the DA says, we just don't have enough proof. We're not going to proceed with an indictment. Fine. And then the next thing you know, the family of the deceased wants to sue my client for wrongful death. And, there's no statute of limitations on murder, right? So am I going to let my client say anything that might be incriminating, even if they're innocent? I'm not even going to let them say, that they knew the person or that they had any contact with them, because that might be incriminating in and of itself. It doesn't prove the case, but it proves a little piece of the case. So unless I've got an ironclad document in my possession, there's no way in hell that I'm going to have anybody testify willingly, at least, before a plaintiff's attorney in their office during a deposition, if there's any possibility whatsoever that my client could ever be prosecuted. It just doesn't make sense. So the safety measure would be to put it in writing, usually get it signed by a judge, and have it be complete transactional immunity. So that would be the safety measure that should have been put in place, in my opinion.
So I don't know. Maybe that's just a comment from me. I feel like Bill Cosby could get the best lawyer that money could buy. So how does that even happen? I mean, how does it happen where he's going to let this guy who is a bigger than life celebrity, who is America's dad, admit to anything like that without, I don't know. I don't get it. I just don't understand. Maybe you understand because you're a lawyer.
Well, what I don't understand is really two things. And I would encourage anybody to check out what I wrote on this. The title of it is "How Strong is the Criminal Case Against Bill Cosby?" and it's published on CNN opinion page under my CNN profile. And one of the issues that I addressed was, I said, one of the biggest mysteries in this case is why, in the first place, Bill Cosby, with at least one, I think maybe two lawyers in tow, took with him down to the police station, and he gave, this is before the depositions were even an issue, before the lawsuit was filed. This is a year after the fact, or let me rephrase that. This is a year after the alleged sexual assault took place. He goes down with his lawyers and he says, yes, I was there. I gave her pills. We did this, we did that. All the things that she say are true. The only thing that's not true is that it was non-consensual. She says it was non-consensual. I, Bill Cosby, say she was a willing participant. And that's the only area of disagreement between the two. And so that's a mystery to me. Why that happened, I can't tell you. I think as a defense lawyer, the smarter thing to do, in my view, would be to say, Mr. DA or Mr. Police Officer, thank you for bringing this to our attention. We're not even going to dignify that with a response. If they had done that, the police couldn't have even proved she was ever even there. And this case would never have seen a courtroom. But because he went down with his lawyers and gave that statement to the police, that got the ball rolling and it got him successfully sued. So personally, I question the wisdom of doing that, just in the interest of protecting a client, because guilty or not, that statement was what that got this whole ball rolling. So I wrote about that. I said that was one of the biggest mysteries in the case as to why that even was allowed to happen.
Yeah. Okay, so Pipe asked, I've heard in practice the judge never signs such a deal. Is it just theoretical, I've heard, to let a judge sign it? It's not required that it be in writing, and it's not required that a judge sign it. The prosecutor can make a binding agreement. It can even be an oral agreement, as long as you can prove the agreement existed. So the prosecutor can give a verbal agreement or a promise that is binding, that's equivalent of transactional immunity, because it has to do with this issue of being equitable and fair. Because if a prosecutor promises you something and then you rely on that promise to your detriment, i.e. getting sued and later prosecuted, there's an argument to be made that that's just fundamentally unfair and it violates your due process rights. Okay. So they want to know what's needed for a successful appeal, and I'm assuming that appeal on the judge's decision today? Correct. These issues will all be appealed, whether it's appealed pre-trial or in the event of a conviction post-trial remains to be seen. Most of these are discretionary appeals. Now, in some states, and I'm not a Pennsylvania lawyer, and I don't profess to know the answer on this. It's something that we probably can find out fairly easily. But in some states, things that are this important, in some states, it would be called a plea and bar, or something that would stop the prosecution dead in its tracks. If it's so substantial, then the appellate courts can rule on it pre-trial. Most states have a procedure where even if it's not a mandatory
type pretrial appeal. It's a discretionary, or we call it interlocutory appeal. The losing side can ask for the Court of Appeals to make a ruling pretrial. I think in a matter such as immunity from prosecution, that's a very important legal issue. And if he was entitled to immunity, it seems to me that in all likelihood, that's something that an appellate court would review before a trial would proceed.
Okay. So I don't know that you're going to answer this because you're not, I don't know. We'll see. Taylor wants to know how you hope things will turn out for Cosby.
I don't really have a personal opinion on the case as far as what I hope will happen. What I hope will happen is that justice will prevail and that the truth will come out. My opinion about the strength of the state's case, I have written about publicly. And what I can tell you, and I'll just summarize it. I will say that without his statements to the police and without this deposition, if this case had to stand on its own two legs, it would be very weak. Of course, he's presumed innocent. The criminal accusation charges him with indecent assault. It's not evidence. It's just an accusation. So what we typically have is a swearing contest between two individuals, and the only two people that were there apparently were Bill Cosby and Ms. Constance. So they're the only two that really know what happened. So in her case, the problems they would have proving the case is the delay in report. She waited a year. Now, there might be reasons for that a jury could understand, but nevertheless, it's an issue. She went to a plaintiff lawyer before she went to the police. There were at least two occasions, according to what I read in the police charging document, where Cosby is accused of having assaulted or battered her before the 2005 assault. The first one happened a few months after they met in 2001. He's claimed to have touched her pants, waist, and her inner thigh. And the second one was on another unknown date when he allegedly unbuttoned her pants and began touching her. Despite those two events, she went to his home on this particular night when the sexual assault supposedly occurred. And it just doesn't seem like the thing that someone would do if they've been assaulted sexually twice, that you would still go to somebody's house. Could happen, I suppose, but it's something that could give reasonable doubt to a juror. She admits to voluntarily taking unknown pills. And by the way, after the alleged assault occurred, she maintained some type of relationship with him, even visiting him at his home on numerous occasions, not only in Pennsylvania, but in New York and at a casino, I think in Connecticut, if I'm not mistaken. This is all after the alleged criminal sexual assault. So those are the kinds of things that a good cross-examiner could make a lot of hay out of. And so if that was it, the case would be over. But that's not it. Bill Cosby opened his mouth and he talked. And he talked with the permission of his lawyers to the police, and that virtually guarantees that that statement would be admissible. There's still an open question about the deposition testimony. If he reasonably relied on what he thought was a promise, the judge could still rule that's inadmissible, but they've got everything they need from his initial statement to the police.
Well, that's interesting, because I would think that it sounds like he did reasonably rely on that. I'm not citing one way or the other. I'm just saying he's not stupid and his attorney's not stupid. So you would think a judge would maybe seriously look at that.
I agree, because I can't imagine why Bill Cosby or anybody in their right mind would sit down and answer questions under oath, Kathy, if there's any idea that they could conceivably ever be charged with a crime, let alone one that's this serious. So that suggests to me that he had he actually did believe that he was in the clear in terms of a criminal case.
Okay, Taylor's just wanting to know if we know the reasons why the women waited so long. I mean, I think we could assume why they waited so long.
That's kind of a broad question. Many people who are true victims of sexual assault never come forward, and many of them come forward late, years, weeks, months, years, whatever, decades, sometimes later. Sometimes it's outside the statute of limitations. But there might be many reasons why people wouldn't come forward. There are also reasons why people would make up a false allegation of this, especially against somebody who's got lots of money and might be an easy target. And we might have seen an example of that this week in California.
Well, I also think all of those reasons, but I also think, every one of these women were trying to get a career started, and he was the guy. And so I think that has a lot to do with it. Like, how do you go up against this big, powerful guy and destroy your potential career? I think it's a very hard call for a lot of these women. We all think what we would know, we all think we know we would do in that situation, but I don't think we do know.
No, and I think the statistics bear that out. I think that women and men, to a lesser degree, who are victims of sexual assault, there's a stigma associated with it. And so a lot of people just want to bury it, not put it out there in the public domain. Certainly when you are going up to someone as powerful as a person with this money who can hire the best of the best lawyers and has this public persona that Bill Cosby had enjoyed for so long as being America's dad, and Dr. Huxtable, that sort of thing. So, yeah, I can see why somebody might be hesitant to come forward, even in a case of a actual sexual assault.
All right, so I think we could probably start to wrap this up. Why don't you say again what's happening next in the case, what we can expect, when's the next time we're going to see him in court? Well, actually, just for my trial watchers, we don't ever get to see him because Pennsylvania doesn't allow the streaming in the courtroom. But however, why don't you wrap up with what we can expect?
That's very unfortunate about that. I wish we could have something, but we're relegated to having, you can't even live tweet from these courtrooms. The preliminary hearing is scheduled for March 8th at 9:30 a.m. That's a probable cause hearing. And it's basically not a trial, it's a miniature trial where the prosecution gives an overview of its case. They won't show all of their cards. They'll show just enough to convince the judge that a crime probably was committed and that Bill Cosby is probably the one that committed that crime. So we'll get a glimpse at some of the evidence, but it's not going to be a surprise. We know essentially what the evidence is. They laid out very clearly in their affidavit of probable cause what they're basing their case on. But it is March 8th at 9:30 a.m. Unless that gets rescheduled.
Okay, I just want to say that you are also the person actually inside the courtroom for Justin Ross Harris, which is the hot car death that we have coming up there in Georgia. And so we definitely want to do a lot of these Q&As with you about that. And I want to thank you on behalf of everyone for doing this.
Yeah, quite welcome. I'll either be in the courtroom or be in a news truck outside the courtroom. Hopefully, depending on the weather, we can watch the feed from inside the truck. But yes, I've been in court for quite a bunch of that pretrial litigation. But I will definitely be on scene and fairly well plugged into that case. And I've been following it very closely, and it's certainly a very interesting case to say the least. And everybody's on pins and needles to see how it turns out. That, by the way, is scheduled to start on the 11th of April. We predict 6 weeks, including jury selection, so it's going to take a while. But yes, we'll be here for that. And, folks, follow me on Twitter at Phil Holloway ESQ. We'll be live tweeting, and you can check me out on Facebook. Find my public Facebook page on Philip Holloway. That's Philip with one L, HOLLOWAY, and like that public page, and you'll see lots of good information about that and everything else that is going on in the legal world. Okay, great. That's Kathy from Court Chatter. Thank you, Phil, so much, and we'll do this again. All right. Good night, everybody. Thank you.